Swayam Prabha. Digital India. Educated India.
.498A of IPC is to be taken as Section 85 and 86 of BNS, and Section 494 of IPC is to be taken as Section 82 of BNS.
Hello everyone, this is Professor Shivani Goswami and I am teaching in IP University. I am taking few lectures on Hindu law. Today is my lecture 7. We had taken lecture 6 and lecture 6 was on Hindu Minority and Guardianship Act 1956, where we had discussed different types of guardians. We had discussed about the natural guardians, we had discussed about the testamentary guardians, we had discussed about the certified guardians. We also talked about guardian by affinity, de facto guardians, their powers. We had seen that when we talk about the natural guardians, in the case of legitimate children, it is the father and after him it is the mother. In the illegitimate children, it is the mother and after him it is the father. And in case of minor married women, it is the husband who is considered to be the natural guardian. When we talk about this legitimate guardian, and in section 6, the word is after. After doesn't mean that it is after the death of the father. I told that there was a very landmark case of Geeta Hariharan's case, where it was specifically laid down by the court that after means that when the father is a non-functioning guardian. So if he is a non-functioning guardian, then even in his presence, the mother can assume the natural guardianship of the child. And since illegitimate children are always connected with the mother, so that is the reason why she is considered first, and after him, her, it is the father that is there. And in case of a minor married woman, it is the husband, because it has always been felt earlier, and it is also laid down that the women should never be left alone, and the word he plays a very pivotal role in her life during the time when she is a maiden, when she is unmarried. It is her father who takes care of her, and then after her marriage, it is the husband who has control over her, and when she becomes a widow, it is the son. So there is always this he which is there with her and who is controlling her in every arm. So that was the reason that in case of minor married women, the husband was considered to be a natural guardian. And earlier, the father could deprive the mother of testamentary guardianship by appointing a testamentary guardian during his lifetime, and after his death, the mother couldn't assume the natural guardianship. It was a testamentary guardian that was appointed by the father who used to take the guardianship of the child. But with this act, this 1956 act, this has been done away with, and now even if the father has appointed a testamentary guardian, after his death, it would be the mother who would assume the guardianship of the child, and if she during her lifetime appoints anyone as a testamentary guardian, then it is her guardian which would be taking charge of after her death, not the guardian which has been appointed by the father. So this is a very important thing which has come under this present act of 1956. The powers, everything we discussed about section 8 and testamentary guardians, and then we discussed about the certified guardians that's mentioned under the Guardians and the Wards Act, because this act is not in derogation of this Guardian and Wards Act. It is in supplementary and complementary to each other. There were powers of certified guardians also, then guardian by affinity, natural guardian, and it is the last section 13 was talking about the welfare of the minor child. So it's always, whenever the concept relating to child is concerned, the court always takes into consideration the welfare of the child, and number of factors are there to determine this particular thing. It could be the wishes of the child, it could be the wishes of the parents, it could be you see the character of the person who's taking the guardianship, so on and so forth. So this was regarding the Hindu Minority and Guardianship Act, which we had discussed in our previous lecture. Today it's my 7th lecture, and we would be talking about the joint family system. And when we talk about the Hindu joint family system, all of us have heard about a joint family. We do say in our everyday life, they're staying in a joint family, or they're staying in a nuclear family. So these concepts, these terminologies, we are using in our everyday life. Now the question here is, what is a joint family? Now when we talk about the joint family, this joint family is not the normal boon of the present day society. It has existed since ages. It is not a new concept. Its evolution could be the time when we had been living in a male dictatorial, male dominating society, where the eldest male had a control over a family, and all other members in the family, they were obeying the commands of this elder family. And as a result, the members of that family who were there, they were the members of this joint family. In order to establish a joint family, it is necessary that a common ancestor should be there. But for its continuation, it is not necessary that this common ancestor should be there. Old people die, new children are born in the family, new people are coming in the family, in the sense that I'll be giving you an example of that, and the joint family continues till perpetuity. So when you have to begin with you establish a joint family, a common ancestor is a requirement, but for its continuation, this common ancestor, it's not necessary, and he might die and newer generations are being added, and the joint family continues till perpetuity, maybe till perpetuity in existence. Then there are people who could be, when you are born in a family, automatically you become a part of that family. If a child is born in a family, that child becomes a part of that particular family. So then it's not that there is any agreement or contract that is being entered into, that from today onwards this child is a member of this family. You are born in that family, you are a part of that family. You automatically become a part of that family. So that means we could say, if we can say, that it's all the blood relationship that constitutes a part of joint family. But it is not like so. It could be even members from outside. Outside in the sense, for example, if in a family a marriage takes place, so the woman who is coming from outside, she was not born in that family, but now after her marriage, she is a part of that family. And as a result, she is a part of that joint family. So she was an outsider, not born in that family. So when she gets married into that family, that means now she is also a part. So you are adding members in a joint family. The children who are born in that family, they are being added in that family, and they become a part of that joint family. It could be that when you have adopted a child, now that child is not born in this family. He is in the other family. He's born in that natural family. We had talked in one of our lectures, I think lecture 5, we talked about Hindu Adoption and Maintenance Act 1956, and we had discussed there that when you talk about adoption, after adoption, the child becomes a member of that adoptive family. So that means his ties in the natural family are broken, and now it becomes a part of that joint family. So all his rights, liability, obligations, everything now is there in this adoptive family where the adoption has taken place. So that means if in this case of joint family, a child is being adopted from another family, the day from when he is being adopted, he becomes a member of that family. He is not born in that family, but he's born in another family, but having that adoption thing, if he's being adopted in that family, he becomes a part of, he's being added and he becomes a part of that family, and all his rights, obligations, duties, everything now is there in this particular joint family. So that means even people from outside, they can come and become a part of a Hindu joint family. When we talk about the incidents, there is no restriction as to the number of people in the joint family. There is no restriction as to number of people. There is no restriction as to number of generations. everyone in there is a part of that joint family, and that limitation or restriction is not there. Then it can also happen that like you are being added in that family, you can also lose the status from a joint family. For example, if a child is born in this joint family and later on he is given in adoption to another family, then he loses his right in this joint family and he becomes a part of that family to where he is being given in adoption. So that means he has lost this right of this joint family. He has lost the membership of this joint family. When daughters of the family, they are given in marriage to another family, and that means now they are becoming a part of that other family. That other family, of course, is her husband's family. So that means now the daughter who are part of this family, they are becoming member of the other family and they are losing their status. So now we have this thing that after Hindu Succession Amendment Act 2005, she is still a co-person in this her family, this family, but after her marriage, she loses and she goes into her husband's family, and she becomes a part of that family. Then it could be that you have converted to another religion. It could be that you have become a non-Hindu. Yeah. It could be that you have undergone a marriage under Special Marriage Act 1954. And all of us know that it's basically for the purpose interreligious marriages when people belong to different religion. So if you're getting married to a person who belongs to a non-Hindu religion under Special Marriage Act, then you loses your status of being a part of this joint family because your ties are severed in this family. So that means people, if we see it, I have told that there is no restriction to the number of people. I have told that it could be up to any generations. It could be you can be added in the joint family. You can be subtracted from the joint family and you lose your status in that joint family. So, but one thing is that joint family, because I stated that older people might die, newer ones may be added and children might be born. People will keep on adding and joint family would continue in perpetuity. It might continue till forever. So then when we talk about the members of the joint family, of course, it is the lineal descendants male, their wives, it could be unmarried daughters, children, it could be dependents in the family, it could be the adopted children, the unmarried daughters in the family. So they are all part of the joint family and they are the members of a Hindu joint family. Then apart from this, if you talk about the rights of this, it could be, the common enjoyment. When they are all part of the joint family, nothing is specific. Nobody can say that this is his share or this is her share. So you cannot touch it. It's a common enjoyment, common possession. All are members of this family and they are the part of joint family and they have a right of equal possession, equal enjoyment, and there is no certainty as to a particular share, nothing of that sort. So you are enjoying it as a whole. Then you have a right of residence. You have a right of maintenance. We talked about maintenance again under Hindu Adoption and Maintenance Act 1956, and it's all your basic necessities. It could be food, clothing, shelter, education, your medical expenses, it could be, so all these are covered, your basic necessities in life, your standard of living, it's covered under maintenance. So all these members of the Hindu joint family, they have got this right of maintenance, and till they are the ones who can claim maintenance because they have this particular right. Then when we talk about the joint family, we do believe that there is always a presumption of jointness. So that means it's a court, the presumption is in the court. So the court always believes that if it's a Hindu family and until and unless the contrary is proved, there is always a presumption of food, worship, estate. So that's a joint family. In the absence of partition, when it is proved, there is always a presumption that it is a case of a joint family. And if partition has taken place and there is a proof regarding it, and if any other person says it otherwise, the burden of proof would lie on him to prove that no partition has taken place and it is still a case of a joint family. For a joint family, it is not necessary that you need to live under one roof. It might happen, supposing, let's take an example here. There's a joint family in Delhi. Say A is the father, B, C, D are his sons. Now, the family is in Delhi. Due to job purposes, B has to go to Chandigarh, and he, along with his family, maybe he has a wife and a children, he goes for the job purposes, he goes and stays in Chandigarh. Then another one goes to Bangalore, and the third one is in Delhi only, and they are with their families. Now, here everyone is separated in the sense, I'll not say separation in that sense. They are all living, they are not living under one roof. So people do believe that in order to constitute a joint family, it is necessary that you should be living under one roof. But that is not a requirement. Why? I have my reasons behind it. Because one has gone for the job purpose, another might have gone for the business purpose. They have not, the joint family status will come to an end only when partition takes place. So until and unless the partition has taken place in this joint family, the family would continue to remain joint, even though they are not living under one roof. They might be living under different roofs, but if there is no partition in this joint family, so that means the status of a joint family, it comes to an end by one mode, and that is partition. Partition, all of us know, when you are demarcating the shares, there is a severance of status, and then partition by metes and bounds. Partition by metes and bounds is the actual division of the property. So until and unless this has taken place, and for this it is necessary that you should have an unequivocal intention, and it should be communicated to all the co-partners. The co-partners are, I will be coming on who is a co-partner after this. So you need to communicate your intention. Only then your partition of this family takes place. But until and unless this is done, it is a joint family. Howsoever you might be living under different roofs, you might be living under different states, till the time partition has taken place in the family, it continues to be a joint Hindu family. For a partition, though I'll be taking different lecture on partition, but for a partition, it is necessary that you need to communicate. If you have not communicated your intention to anyone, then it's not the case of, you need to communicate it to the co-partners who are the interested parties, and only then partition of that joint family would take place. You don't have to assign any motive. You don't have to assign any reasons. You don't have to say that your wife is not comfortable with your mother-in-law, and that is the reason why you want to separate from this joint family. You need to just communicate your intention, and this partition would take place. The formalities would take place later on, but your severance of status from the family would take place the moment you have communicated your intention to the interested parties who are the co-partners in the joint family. So in that case, it would be divided. Now, when we talk about the joint family, this thing is Mitakshara joint family and the Dayabhaga joint family. First, I would be dealing with the Mitakshara joint family, and secondly, I will be dealing with the Dayabhaga joint family. Now, when we talk about Mitakshara joint family, this is a family, this system, Mitakshara system, is applicable throughout India except for the states of West Bengal, Bihar, Assam and Puducherry. So that means throughout India except for West Bengal, Assam, this system is applicable. That means in a majority of the cases, it is the Mitakshara system which is applicable. When we talk, now there is a term co-partnery. The question is, what is co-partnery? We have studied about joint family system, and now I'll be talking about the co-partnery, this thing. Joint family is a bigger institution. It's a very broad, very wide, very big institution, because every member of that family is a part of a joint family. But co-partnery is a narrower body of persons, right? It is not that much big. They are the members of the joint family, but limited number of members of joint family. So that means every member of the co-partnery is a part of a joint family, but every joint family is not a co-partnery. Joint family is a genus to which we can say co-partnery is a species. So every member, when we say that Kopasri is a narrower body of persons, and when we talk about the Mitakshara school, under it consists of a common ancestor and 3 lineal generations. When we talk about this common ancestor and 3 lineal generation, I mean to say these particular persons, that means a common ancestor with 3 lineal generations, so up to people of 3 generations, they are all Kopasnas in this joint family. So the people who are coming beyond that 3 generations in that particular Kopasri, they are not the members of Kopasri, and the word Kopasnar is very, very important because these are the people who have got various powers, and they are the ones, the most important part which they have is they are the ones who can demand partition of the joint family property. So that means if you have to demand partition, the right is not given to each and every member of the family. It is given only to the limited number of people in the family. These limited number of people are Kopasnas, and they are the only ones who have got a right to demand partition. And of course, when partition takes place, they also get a share in that property. So these people are very, very important. It is not given to every member of the family. Only these members of the family who are limited in number, as I've already told, they are the ones who can seek, who can demand, who can ask for partition of the joint Hindu family property. Now, when we talk about these Kopasnas, I am talking under Mitakshara law. Here I stated that you need to have a common ancestor and 3 lineal generations. Now, in my slide, if you see it, here I have drawn this thing. If you see this thing, I will be explaining it with the help of this only. Here it's the father, S1 is the son, S2 is the son of S1, S3 is the son of S2, and S4 is the son of S3. Now, if you see it, the first one is of course the original holder. It has been starting, I said it's a common ancestor with 3 lineal generations. Let's say, now it's the simplest one. S1 is the first generation, S2 is the second generation, and S3 is the third generation. S4 is coming in the 4th generation. The definition says a common ancestor with 3 lineal generations. Now, in this particular diagram, F is the common ancestor. Behind it, you need to take count, you need to add 3 generations. So, S1 is the first generation, S2 is the second generation, and S3 is the third generation. So, all people till S3 generation, they are Kopasnas in this diagram. And the S4 might be, it is S5 if you go on downwards. They are not coming within that limit. So that means they are not Kopasnas. In this particular diagram, F is the common ancestor. The S1 is the first generation. S2 is the second generation. It's also written here. And S3 is the third generation. So F, S1, S2 and S3, they are Kopasnas in this joint family. The family is big. S4 is also there, S5 is also there, S6 is also there. But the Kopasnas are these limited number of people. And these limited number of people, they only have got a right to demand partition. So that means F, S1, S2 and S3. In this particular diagram, they can ask for partition and they are the ones who will demand partition in this joint family property. Let's proceed further. I'll just draw it here. Now, F is in this particular diagram, F is the father. These are all generations. Son, S1 is the son of F, S2 is the son of S1, S3 is the son of S2, so on and so forth. Now, I have stated that in this particular joint family, F, S1, S2 and S3, till S3, all are Kopasnas. You know, nothing can be said. Anyone can die. Though there's a belief that the older people die and younger one will die later, but it's not like that. Even a young person can in an accident die, or he might be suffering from a serious ailment and he dies before the older generation. So older generation might be there and the younger ones might die. It can happen like that. Let's take an example here. For example, in this particular diagram, S2 dies. Now when I am putting a thing in a bracket, I mean to say that this person has died. Now here, though S2 have died, it is the copostory would still be F, S1 and S3. So these are the copartners in this copostory. It will not move further because this person S3 is coming within the limit of this 4th generation inclusive of the father, and they are copartners. So I have already stated it is a common ancestor with 3 lineal generations. Since F is alive, so this will not move further. It will be F, S1 and S3. Let's say after this S3 dies, the copostory is F and S1. It will not move further because it's a common ancestor with 3 lineal generations. Till the time F is alive, it cannot move further. Then let's proceed further. Supposingly S1 also dies. Now in this copostory, F is the sole surviving copartner. Why I am saying so is because in this particular copostory, he is the only one who is left. So he is the sole surviving copartner. If now he dies, S4 will become the last holder, and after him again, so last holder with 3 generations. This is the 1st generation, 2nd generation and 3rd generation. So in this it would be S4, S5, S6 and S7 who will become the copartners. One doesn't have to be removed by more than 4 degrees from the last holder. Howsoever he might be, he could be removed by the original. In this particular thing, only F was the original and the last holder. If he dies, this one, had it been like this, F would have died first. Now he is not a sole surviving copartner here. F would have died first. Then what would have happened was S1 here would become the last holder, and because this has died, and now you have to count next 3 generations. So 1, 2 and 3. This one is S4. So that means here S1, S2, S3 and S4, they are all copartners in this joint family. Had it been the S5 and S6, they are not coming in this copostory. Similarly, if he died, now S2 will become the last holder and you will shift further. This one will become the 1st generation, this one the 2nd generation, and this one will become the 3rd generation. Now S5 will be included in this particular copostory. So it goes on like this. I stated that these are very important and these are the ones who can claim partition. These are the ones who have got a right to ask for partition. Here I would like to explain one thing more. I have just explained you the simplest form. It could be like this, because it is not necessary that in a generation you just have one person. It could be generation is you and your siblings. C, D. He has 2 sons, B1, B2. Then it's C1, C2, it might be C3 also. It could be D1 and D2. It could be B3. Then he might have another children, C4, C5. D1 again could have D3 and D4. It could be like this. Now, here if you see who are the copartners in this particular case, because I had taken it from a very simplest form when I had taken single person, but it's not that single. We are talking about the common ancestor and 3 lineal generations. Now here A is the common ancestor, 3 lineal generations. This one is the 1st generation. All these persons, they will come in the 2nd generation, and this one will come in the 3rd generation. 1, 2, 3. A common ancestor A with 3 generations. 1, 2, 3. So that means till D4, everyone is a copartner. D5 is not a copartner because he is coming beyond that limit of 4 generations, 4 degrees inclusive of the common ancestor. So D5 here is not a copartner. Now, when we talk about the Mitakshara Kopasnari, it states that you have community of interest and unity of possession. So that means till the time everyone is there, you are a part of this joint family system. It's a common enjoyment, common possession. No one can say with certainty as to this is his share, this is her share. Everyone has got a right to enjoy this property. In Mitakshara Kopasnari, the son, and son. That means till 3 generations, these persons are born with the property. Now, what do I mean to say about born with the property? In the case of ancestral property, I'll be talking about the self-acquired or ancestral property. In the case of ancestral property, these 3 lineal generations, son, and son, they have got a birthright in that property. I'm talking about ancestral property, again I'll say. And birthright means that they are born with the property. So if any person without their consent alienates the property, these persons can drag that person to the court, because they also have got a birthright in that property. If you have not taken the consent and you are just alienating it without any necessity, without any exceptional case, then they can move to the court, because they also have that right. They are born with that property. They have got a birthright in that property. And at any point of time, they can demand partition. They are co-partners of their property. So these people are very important, I have already stated. And earlier, daughters were not co-partner, but with the passing of Hindu Succession Amendment Act 2005, now daughters are also co-partners in the joint family. So that means they also have got a right to demand partition of the joint family property. They are being treated at par with the sons in the family, so they can also demand partition of the joint family property. Now, first right, I have already stated, they are the ones who demand partition. They get a share when the property is divided. Then, if you see it, I have already told that they all enjoy the property together. It's a unity of possession, and community of interest and unity of possession is there. Then, it is also, if there is an adopted child in the family and an adoption has taken place, he is also a co-partner in that joint family, and he also has got a right to demand his share. Because I have already told so many times that after adoption, this adopted child rights are also at par with the natural born children, and since they can also demand partition, they are co-partners. He also becomes co-partner in the family, provided he is coming within those limits that are being prescribed, so he can also demand partition of the joint family property. There could be insane person in the family. Now, insane persons, they are considered to be disqualified, although they are co-partners, but till the time they are insane, they cannot demand partition and they do not get a share when the property is divided. But if they are revived of their insanity and they are cured, obviously they will take their share in the property. In any case, if they have a son or a daughter, they have a right and they are not debarred from taking the property. Then it is also possible that the son of the family gets married to a woman who is a non-Hindu, and he goes under Special Marriage Act and solemnizes his marriage. So under Special Marriage Act 1954. Now, the question is, can the son now which is born to this particular person who has undergone a marriage with this non-Hindu woman under Special Marriage Act, can he constitute a co-partner with this person? That's for sure that when he has performed a marriage with the non-Hindu under Special Marriage Act, his ties in this particular joint family are broken. But he still can form a co-partner with his son, provided he is being brought up as a Hindu. So that means if the child is being brought up as a Hindu, a co-partner can come into existence between this person who had undergone a marriage under Special Marriage Act and the child who is born. The requirement is that he needs to be brought up as a Hindu, and they can constitute a co-partner. There are many rights of co-partners. I have already stated few of them. They are the ones, but the most important right that they have is right to ask for partition and to take a share when the property is divided. It is also possible that I have said number of times that all the co-partners, they have equal right in the property. So that means if there is a minor co-partner in the family, you cannot do like this, that he being a minor, so he will not, we can do anything and we will take more share and give less share to him. That's not possible. And then this person also through his next friend as a guardian can ask for partition because he is a co-partner in the family. So co-partners have got this right. Even a person who is abroad, he can also ask, he being a co-partner, anyone being a co-partner can ask for partition of the joint family property, and these persons gets a share when the property is divided. These are the persons who could restrict if an improper alienation is, it could be transfer of property by gift, sale, mortgage, so on and so forth. And if any of your sisters, they are improperly alienating the property, the co-partners can restrict them and they can stop them from improperly alienating it. So that means if there is no exceptional case, it's not the case of legal necessity, it's not the case of benefit of estate, it is not the case of the act of indispensable duties, it could be any religious ceremonies, it could be shraddh or something like that, then the person is improperly alienating the property, the co-partners have got full right to challenge that improper alienation because they have the birthright in that property. Without their consent or until and unless it is an exceptional case, you cannot do it, you are not allowed to alienate the property. If they have given the consent or it's an exceptional case, then the property could be alienated. Otherwise, they are the ones who could move to the court and challenge that improper alienation. Then as far as the property is concerned, we could divide it into joint family property or separate or self-acquired property. The joint family property is basically your ancestral property. It could be what you have taken from your father, grandfather or great-grandfather on the paternal side. So that means ancestral property is only on the paternal side, father, grandfather or great-grandfather. If you take any property from your maternal grandfather, that is not your ancestral property. That could be considered as separate or self-acquired property. In the case of ancestral property, you have got a birthright and it cannot be improperly alienated. But in the case of a self-acquired or separate property of a person, he has got, it is at his own will, at his own discretion that he could dispose of the property. If you are not serving your parents, the father might give away his self-acquired or separate property to an orphanage, to your neighbor, and he might say that I will not give it to you because you have not taken care of me. So you do not have any right in that property. It is his will, his property, he could dispose it of the way he likes. Separate or self-acquired property could be anything. It could be the gift, any gift that you receive, it could be at any point of time, that's your separate property. It could be the property that you receive from people other than your father, grandfather or great-grandfather on the paternal side. It could be any property that you receive on partition and you do not have an offspring. So that property, if you, before any offspring is born and you dispose of that property, that's well and good. It's your separate property. But the moment a child is born, the status of that separate property would turn into a joint family property or a co-pastory property, and now you cannot alienate the way you like, because now this, your son which is born also has a right in that property. The co-pastory would start. Then any grants received from the government, the property that you acquire through your own skills, through your own labor, through gains of learning, it's the case of a separate property, and under these property, you could dispose it of the way you like. I mean, nobody can challenge it. Your sons cannot challenge it in the court. It's your property. You have earned it. You could dispose it of the way you like. You could give it to any person the way you like. The same scenario, you cannot do it if it's a case of a joint family property or an ancestral property. So in that, your children can move to the court and they can challenge that alienation. Now when we talk about the karta, Karta. Karta is the senior most member of the family, and it's usually the senior most member of the family, and he's the one who is managing everything in the family. His power is, position is sui generis, and he is the one who takes care of the family. He's the one who is holding the family. He is the one who is deciding everything relating to the family. He has got the power to compromise. He has got the power to contract, power to refer a matter to an arbitrator. So he has lot many powers, and he has duties and liabilities also. So not to forget on that point. In the presence of a senior member, a junior member can become, it might happen that when you are senior, you are aged person, you are not well, you are not in your senses. So diseases come when you become old. So, and it's not possible for such kind of a person now to take care of the family. So even in the presence of a senior member, a junior member can become the Karta of the joint family. But for this, it is necessary that all the other co-partners should give their consent to it. So junior member can also become, provided the other co-partners give consent. But as far as normally it is a senior most member and his position is sui generis. You don't have to take the consent of anyone in that case. You become, because being a senior most member, you have got this right and you become. There are lot many privileges, there are lot many duties, lot many responsibilities as far as Karta is concerned. Karta's power of alienation is very, very important. Earlier, Vignaneshwara has stated that in only 3 cases this could be done, and that were Apatkale, Kutumbarte or Dharamarte. And Apatkale, we know that it's a case of emergency. Kutumbarte is for the sake of family, and Dharamarte is for dharm, for all those purposes. But now this has been modified, and we have the terminologies are legal necessity, benefit of estate, act of indispensable duties. Legal necessity cover everything that was there under your Apatkale, and it also covers one part of Kutumbarte, that is for the sake of family members. And benefit of estate is relating to the estate. The second part, which is relating to the property of Kutumbarte, and the third one, act of indispensable duties, is what was covered under Dharamarte. So these things are covered. Legal necessity basically is your necessities. It could be food, clothing, shelter, education. It could be the medical expenses. It could be taxes. It could be you are defending a family member when he has been prosecuted for murder. But if it is cases of the murder of a family member, then it's not allowed. So in these cases, the Karta can, without the consent of the co-partners, or because these are exceptional cases, can dispose of the joint family property. Otherwise, he doesn't have any right. But if he has these are the exceptional cases, whether it is legal necessity, whether it is benefit of estate, whether it is act of indispensable duties. In this, he doesn't require the consent of the co-partners if it is a case of a joint family property. He could dispose it of the way he likes, the way he wants. So nobody can challenge it. Then benefit of estate is relating to the estate, that means the land. So it might happen that you have a less profit yielding land in a village which is so far off and which you cannot take care of. So if you purchase a land which is close to you, you build a 5-star hotel, you have now ample of money coming from it, it's a case of a benefit of estate. But selling a land and keeping it in your bank account, it will not come under your benefit of estate. That's basically relating to land. Selling off those less yielding and getting more profit out of it, but it has to be related to something with the land. So that's a case of benefit of estate. The Karta has got full power to alienate the joint family property if it is relating to benefit of estate. This also comes under exceptional case, and here the co-partners, if the Karta alienates the property, because of this the other co-partners cannot challenge it, because it is an exceptional case. Then the last one is the act of indispensable duties. Act of the religious duties. Anything you do it for Shraddh, Upnayan ceremony, religious ceremonies, these are exceptional cases. So nobody is going to, if you dispose of the ancestral property for this, without the consent of the co-partners do not have remedy under it, and they cannot do anything. Because these are the cases, I have already stated that if it is a case of exceptions like legal necessity, benefit of estate, or act of indispensable duties, then it's an exceptional case. And then even if you are disposing of the joint family property without taking the consent of the co-partners cannot drag you to the court. Otherwise, they have got full right. If you are alienating the joint family property, If it is either without their consent or it's not an exceptional case, then they can drag and take you to the court and they can challenge the alienation, because they have the birthright in the property, they are born with the property, they are the ones who are looking after, and they can at any time work out their right of partition. They can at any point of time demand partition of the joint family property. When you talk about, there's a lot of distinction between a co-pastory and a joint family. I've already stated that joint family is a bigger institution, co-pastory is a part of it. Joint family is a genus, of which co-pastory is a species. There is a restriction of number of people in the case of co-pastory, which is not there in the case of a joint family system. The member of a joint family, but all females, cannot be the members of the co-pastory. The right is given only to the daughters of the family, or son's daughter or son's daughter. So that is the only thing that is allowed. But otherwise, and that too, it was by Hindu Succession Amendment Act 2005. Earlier, daughters were also not included. So females in a way could not be a part of this co-pastory. But now they are being allowed, but the allowance is only in the case of daughters and not to other female members of the family in the co-pastory. Then apart from this, we can also say that they have the members of the joint family and the co-pastory members of the joint family, they have got right of maintenance. Everyone, whether if you are a member of a joint family, so every member of the joint family can ask for maintenance. But as far as the co-partners are concerned, they have got a very specific right, and that right is of demanding partition, which is not given to every member of the joint family. It is only given to this right. I have been again and again saying the most important right of the co-partner is that he has got a right to demand partition, to ask for partition of the joint family property, which other members do not get. Disqualification is another thing. Even if you are a disqualified member of a joint family, you have a right of maintenance. But if you are a disqualified co-partner, during the time of that disqualification, if you are insane, you are not going to get any property and you cannot demand partition. But that doesn't mean it is once for all. If you are cured of this insanity, then obviously you can take your share and you can ask for partition and you can get the partition reopened and you can get your share. So that's not lost for all. It's only during the time when if you are insane. So at that time, that's not allowed. Now I'll be talking about another joint family system, that is the Daya-Bhaga joint family system. It is applicable to the limited states. As I stated in the beginning only that Mitakshara is applicable throughout India except for the state of Assam and West Bengal. So that means in these states it is the Daya-Bhaga that is applicable. Now Daya-Bhaga co-partnery is totally different from what we have it under the Mitakshara co-partnery. Mitakshara, I have stated that your son, 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 son. They have got a birthright in that property and they are born with the property. They can demand partition at any point of time. The same scenario is not there in Daya-Bhaga because under Daya-Bhaga, you do not have any right to do so. I'll explain it again with the help of a diagram here. Let's say I'm talking about Daya-Bhaga joint family now. This is a father, A, B and C. Now that's A's daughter, let's say that this way, B's son and C's daughter. Now this is the case of a Daya-Bhaga joint family. Let's see to the slide. F is the father and A, B and C are his sons, and then A has a daughter AD, B has a son BS and C has a daughter CD. Now in this case, it's a case of a Daya-Bhaga joint family. Till the time the father is alive, he is an absolute owner of the property. When I say he is an absolute owner of the property, I mean to say that he is the one who has got a complete control of self-acquired property also and of a joint family property also. So joint family property, co-pastory property or ancestral property, we usually use it under one terminology only. And so till the time he is alive, he is an absolute owner of the property, and during his lifetime, he could dispose of the property the way he likes. After his death, I am putting it in bracket, that means this person has died. After his death, the copastory would come for the first time in existence, and it would only be between A, B and C. Now so that means it is not going further as we had it in the Mitakshra family. So when it is A, B and C, so that means there are 3 people here. So it's 1 by third, 1 by third and 1 by third. Now during his lifetime, A can use this property of 1 by third the way he likes. He could dispose it off, he might not dispose it off, and this is his absolute property. And if he doesn't spend it and he dies, then the copastory would consist of AD, B and C. So it would be AD, B and C. They are all copastors now here. AD, B and C. Supposingly B also dies. The copastory is AD, BS and C. So it would go like this, AD, BS and C. So this goes like this. So that means people 3 generations are not there. It goes 1 by 1 and the copastory comes into existence for the first time only on the death of the father. But one thing that needs to be remembered here is in the Daya Bhaga, if you see this diagram, had it been that this father had 3 daughters or he has a wife and 2 daughters, so that means all are females. This under Daya Bhaga, the copastory cannot start exclusively with females, neither it can end exclusively with females. There has to be one male, at least one male, in order to constitute a copastory under the Daya Bhaga school. So the one thing that needs to be remembered under the Daya Bhaga school is that one male has to be there in order that the copastory should be there. It cannot start exclusively with female, it cannot end exclusively with female. But till the time the father is alive, there is no copastory. He's an absolute owner of the property, whether it's a joint family property, whether it's a self-acquired property. I mean, the scenario is same. Here also, if you see the joint family property, you could have it ancestral property. And this, the property which is thrown into common stock, all the members, they are coming and they are pooling in common resources. That's again is a case of a joint family property. You are earning it and all of you are throwing it into the common stock. Different members are throwing it into common stock. That means your intention is that it should be treated as a joint family property. So whatever property is, whether it is ancestral, whether it is separate or self-acquired, the father during his lifetime can spend it the way he likes. He doesn't have to see his children, or the children do not have any right in that property. It will come into existence only after the death of the father. So that means copastory would come during that point of time. Joint family property, and in Daya Bhaga school also, the concept is same regarding the joint family property and the self-acquired property. So I have already told that property which is not acquired together by the members of the family, ancestral property, property thrown into common stock, property which is through the support of joint members, it constitute a joint family property. And self-acquired property is again which you are earning it through your skills. It's your property, you have earned it through your own labor. And under Daya Bhaga, there is a concept of Sapratibandha Daya, and under Mitakshra, there is a concept of Apratibandha Daya. Apratibandha Daya is unobstructed heritage. In Mitakshra, there is no obstruction. Even if you are born, the son, son, son and son, 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 they have got a birthright in that property. So there is no obstruction. So that's a case of Apratibandha Daya. And in the Daya Bhaga, it is the obstruction is that it comes into operation only after the death of the concerned person. So this death is the obstruction, and till the time the death takes place, the copastory would never come into existence. So that's a case of Sapratibandha Daya. Then if we talk about the differences between Mitakshra and Daya Bhaga, they are very clear in the sense that Mitakshra, it is 3 generations with the common ancestors, the children, grandchildren or great-grandchildren, they have got birthright in that property, at any point of time they can ask for partition. They have got a right to challenge it at any point of time, and they are the ones who could restrict improper alienation. There is it's a succession now in Mitaksha. Earlier it was survivorship, but now it is succession only after Hindu Succession and Amendment Act 2005. In Daya Bhaga, it used to be succession only. But in Daya Bhaga, the difference is that the kopassery would come for the first time into existence only after the death of the father, and it goes generation by generation. It's not that you are covering 3 generations at one go and they are all the kopasnas. So I've explained it with the help of the diagram also. So it comes into existence only after the death of the father, and during the lifetime of the father he could dispose of the property, whether it is self-acquired, whether it is ancestral, the way he likes. Nobody can challenge it. The children they are not kopasnas even during that time. They become kopasnas for the first time only after the death of the father, and so that means death needs to take place in the case of Daya Bhaga school, which is not the same scenario if we talk about the Mitaksha joint family. Then as far as I've already talked this, Mitaksha, it came in the 11th century, Daya Bhaga came in the 14th century, and when we say that partition can be demanded in the case of Mitaksha, I mean to say that because they have got a birthright in the property, they can ask for partition at any point of time, and for asking of partition, they need not assign any reason, they need not assign any motive. The only requirement is that they have to form an unequivocal intention, and that intention needs to be communicated to the interested parties. There is a similarity also between Mitaksha and Daya Bhaga. Ancestral property concept remains the same, the powers of the Karta, it remains the same, and then females are now recognized. Earlier females were not there under the Mitaksha, but now they are recognized, and in Daya Bhaga they used to be there from the very beginning only. As far as the females under the Mitaksha is concerned, the right is, the privilege is given only to the daughters and not all females in the family, but in any case daughters are also female, so that means female thing is also there under it. And there is a presumption of jointness in the case of Mitaksha. The similar is the case with respect to Daya Bhaga joint family. With this, I come to an end of my lecture, and it was basically on the joint family system. We talked about a Hindu joint family, we talked about the Mitaksha school, we talked about the Daya Bhaga joint family, the Mitaksha joint family, and we talked about the similarity and differences also. I had explained it with the help of the diagrams, hope it was comprehensible, and thank you so much for attending, thank you so much for the patient hearing, and with this I bring to an end of my presentation. Thank you.
Understanding oneself, understanding others, understanding society at large, understanding the nature, these are all driven by basic human curiosity. We would all love to understand why things happen, what happens, what is the final outcome, why certain things fail. These are all exercises that we perform in various domains of knowledge. Therefore, knowledge in various domains, you would realize they are actually social artifacts. They have to be rooted into historical perspective, they have to be culturally salient, and there would be socio-political reasons behind this. Whether you talk with respect to engineering sciences, whether you talk with respect to physical sciences, biological sciences, social sciences, that's the reason why humanities and social sciences should be understood by all of us. The knowledge that is segregated, that is divided with respect to areas, specializations, all of them needs to be understood in its context. And what provides the context? It is the social reality. How do you correlate knowledge in a given domain with the cultural reality, with the social reality, with the socio-political compulsions? Okay, how do you understand the law of nature, okay, in its totality? And for doing that, you require the understanding of humanities and social sciences. Say for instance, if you are trying to understand the effect of a particular bacteria, a virus, any microbe, how it affects behavior, how it affects the organism, human being, you start looking at it from a pure biological point of view. If you are trying to look at a particular type of a wavelength, say for example, you are emphasizing on the understanding of the effect of radiation on human life, you are looking at things from a physical point of view. You are looking at the corresponding changes inside the body, you are looking at the physiological side of the understanding of the information. You are trying to understand why, despite knowing the risk that is inbuilt in the process, why still human beings engage into it. You are looking at it from a pure behavioral point of view. Why society at large admire things which has full of risk. You are trying to understand things from a pure sociological point of view. Why people use particular set of words to explain those experiences. You are trying to understand things from the linguistic point of view. So, there are a whole lot of things, and then finally, you try to combine all of them to say that what are the guiding principles in life. Then you say you are looking at life, you are looking at humanity from a pure philosophical point of view. And this is what social sciences courses provide you. They provide the context to you in which you would be finally positioning the understanding of the knowledge in any given domain. It could be engineering, it could be sciences, it could be medical sciences, it could be social sciences stuff, it could be humanities stuff. So, contextualizing the knowledge is what humanities social science courses help you obtain.